Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. You know, it's not often that we actually get exciting cases off the advance sheets here in the state of Washington, but today is one of those days. Yeah, we've had a real interesting development as it relates to an issue that, candidly, I hope none of my viewers ever have to deal with. But this is a problem for people who are charged with crimes, especially serious crimes. And there's a real question now as to what the state's been doing for years and years and years as to whether or not it was even constitutional. So today we're going to spend a few minutes and talk about, are pretrial orders to surrender firearms unconstitutional in Washington state? Okay, before we get going down the road we're going down, proud to announce that this video is being brought to you by Securite Gun Club. That's right, Washington's nicest indoor facility is located right here in Woodinville, Washington. Now listen, I'm bragging all the time about the facility, I'm bragging all the time about the people who work here, and I'm certainly bragging all the time about the training and education. But this month I want to brag about the toy drive they're doing for the Forgotten Children's Fund. It's going on regular business hours. You can stop down here, help fill this car up with toys for the kids, or you can stop off at the counters and make a donation. Their hours, they're open now. This is important. They're open every day except for Mondays, 11 a.m. to 7 p.m. So stop by, see the good folks here at Securite Gun Club, and help the kids out. Okay, so most of my viewers probably do not know this, but in Washington state, if you get charged with a felony, a violent felony, a serious crime, or a domestic violence offense, even at a misdemeanor level, the court at your arraignment, when conditions of release are set, and they talk about bail, and they talk about no contact orders, and they talk about all the other things that a defendant is going to get tied up on while the case is pending, they almost always will routinely order that a individual must surrender all firearms and can no longer possess firearms and or their CPL for the pendency of the case. So, in many cases in which I have represented people on felonies, when we appear at arraignment, or oftentimes even at our first appearance when they're making a probable cause determination, even if the defendant is going to be kicked loose on a PR with no bail, there will be all sorts of conditions of release placed on him, and almost religiously a surrender of a firearm order for any violent offense, felony offense, or domestic violence offense is going to be ordered by the court. Now listen, and this is important, the minute the court signs that order with the defendant sitting in the courtroom, they are at that exact moment not allowed to possess firearms, to own firearms, or to have a concealed pistol license, okay, at that very moment. The problem is that once that order is served on them, the individual then is required to turn over all of their firearms to law enforcement, that is, surrender their firearms to law enforcement, or in the alternative, if they don't have firearms to surrender, they must file a declaration under penalty of perjury called the Declaration of Non-Surrender. Both of those are compulsory. That is, that the statutory scheme here that governs these first appearances and what happens mandates that an individual is either going to turn all of their guns and their CPLs over to law enforcement, or they're going to file a declaration under penalty of perjury that they have nothing to give up. Those are the only two choices. There is no third option. Well, apparently there was a gentleman who thought there was a third option, and that is Dwayne Allen Flannery. Because this case, which just came out today, State v. Flannery, is a case that now calls into question the constitutionality of this gun seizure law, these pretrial orders. As a matter of fact, the holdings of this court is, in fact, the statutory scheme that was in place for Mr. Flannery is, in fact, unconstitutional. Okay, the facts of the case are really simple, and I'm going to tell you, Mr. Flannery, you got balls as big as grapefruits, because this turned out well for you, but this could have gone really bad. Mr. Flannery was accused of assault in the second-degree domestic violence. That's a very serious offense, and I'm in no way commenting on his guilt or innocence. I do not know anything about the underlying allegations whatsoever, but that was the allegations against Mr. Flannery. After his first appearance, he was ordered to turn in his firearms and or file that declaration of non-surrender. Mr. Flannery chose to do neither intentionally, saying that, you know what, for me to have to turn my firearms over, that is, show you that I have firearms in my possession, after the judge just got done ordering me not to have firearms in my possession, well, that constitutes a violation of my right against self-incrimination. And in addition to that, the fact that even if I don't have firearms, the fact that I'm required to submit a statement under penalty of perjury to that effect, well, that too violates my Fifth Amendment right against self-incrimination. And on top of that, when the court orders me, the state orders me to go back to my home and search through my home and retrieve all firearms, firearm components, and my concealed pistol license, well, that is a search as contemplated under the Fourth Amendment, but it is a search which is not supported by probable cause. So there was a three-prong attack to the state of Washington's pretrial firearms surrender laws, and the attack was successful because not only did the trial court find that this statutory scheme was unconstitutional, that it did violate the Fifth Amendment on not one but two grounds, and that it violated the Fourth Amendment on Washington State, what we call Article 1, Section 7 rights, which are even more protective than the Fourth Amendment. The trial court found that it was a violation on all three grounds. Now, of course, the state of Washington crapped their pants and immediately appealed this to Division 2 of the Court of Appeals, which kind of compromises most of central Washington. Now, Division 2 Court of Appeals in a 3-0 decision has affirmed the trial court, saying that, in fact, this particular legislative scheme and the way we're requiring people who are merely accused of a crime to surrender their firearms after we've already now deemed them ineligible to possess the firearms does, in fact, violate their Fifth Amendment right against self-incrimination. The trial court made very specific findings which the Court of Appeals affirmed, including the following: that the court concludes that the order to surrender weapons and the statutory scheme from which it is derived, requiring that the defendant provide a testimonial statement regarding her possession of weapons that she is legally prohibited from possessing at the time of the declaration, violates the Fifth Amendment privilege against self-incrimination and analogous provisions of Article 1, Section 9 of the Constitution of the State of Washington. And then the court further stated, the court additionally concludes that the order to surrender weapons and the statutory scheme from which it is derived violates the Fourth Amendment of the U.S. Constitution and Article 1, Section 7 of the Constitution of the State of Washington to the extent that the order directs a defendant to search his home for firearms and other dangerous weapons and bring those items to law enforcement during a period when such possession and delivery of those items would constitute a criminal law violation, since there is no immunity from prosecution for him set forth in the statute. Now, you'll see the talk of immunity, and there is a legislative scheme in Washington State, RCW 10.52.090, that says that when people are complying with court orders, any testimonial evidence or other items uncovered from them, they will be granted immunity, which means prosecution cannot then use someone following a court order to obtain evidence to turn around and use it in prosecution. Sounds like a pretty clear-cut case. Yeah, well, the state probably should have read the statute a little bit better, because as it turns out, RCW 10.52.090, which apparently covers well over 100 statutes providing immunity in this exact situation, yet, well, it did not cover any of these pretrial firearms surrender laws. The court specifically stated, the reviser's note following RCW 10.52.090 refers readers to the note following RCW 9.01.120 for the meaning of this act. The note following RCW 9.01.120 explains that this act refers to the laws of 1909, Chapter 249, which codifies over 100 statutes that are listed in the note. The list of statutes in the note does not include any of the statutes in the firearms surrender statutory scheme. Thus, to the extent that RCW 10.52.090 provides immunity from later prosecution, it does not provide immunity for individuals complying with firearms surrender orders. So once again, the case is State v. Flannery. It's out of Division 2, Washington State Court of Appeals. We will link it up in the description box down below. But the crux of the issue is listen, once the court orders a person and deems them now ineligible to possess firearms, We then turn around and through court order immediately require the person to turn over evidence that they are in violation of that order and or provide testimonial evidence as to whether or not they are in compliance with that court order, all in violation of our 4th and 5th Amendment rights. Now, I'm sure the state is going to freak out again. I'm sure this is going to be appealed to the Washington State Supreme Court, and I have my concerns about what will happen to this case once it gets there. In the meantime, if you have any questions about this issue or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.